I'm Richard Gearhart, founder of Gearhart Law, a full-service intellectual property law firm specializing in patent, trademarks, and copyrights. I'm here with intellectual property attorney Ben Schroeder, a member of the Gearhart Law team, and we're going to be talking about an interesting case that sheds some light on claim interpretation. It was recently decided by the Federal Circuit. Ben, why don't you tell us a little bit about the case?
The purpose of the case was to treat heart disease or hypertension. There were two parties, Novartis and MSN. Novartis was a patent holder that had filed patent claims. And in the patent claims were directed to a pharmaceutical composition that had two different ingredients in it. What they found was that by using this combination treatment, they could get better efficacy to treat heart disease. They found that when they used these two compounds in combination, that they got basically better treatment. And their broadest independent claim one actually had claim language. It was directed to a pharmaceutical composition that had these two compounds that were used in combination.
And so the company that was attacking this patent was a generics company, right? Who wanted the patent to be held invalid so that they could sell the combination and take market share away from Novartis and build up their business, right?
And so the company, the generic company, which wanted to invalidate the patent, basically wanted the claim construction decided in such a manner when they instituted the same combination, they did not fit within the scope of that broadest independent claim. And so what they actually did was they argued for a very narrow interpretation of the words in combination.
Also, I think you mentioned earlier when we were talking about this, that the two ingredients together formed a complex, right?
Yeah.
And that was actually the medical unit or the molecular unit that was acting to treat the cardiovascular.
Yeah, that's absolutely correct. The complex that formed was that it did not occur. They didn't recognize that there was a complex until 4 years after filing that initial application.
And then they filed another patent that's claiming the complex.
Yes,
right?
yes, that's correct.
So I think the moral of the story here is that you really have to, number one, know your invention, because they filed a patent, but they didn't really know how it worked. And sometimes that's just the way it is. Mm-hmm. But to the extent that you can actually know what happens with your technology, I think that's important. And number two, careful claim drafting is also really important. So it really makes a big difference having an experienced patent attorney who's familiar with the case law drafting your claims for you, because it can be pretty significant here. And we were discussing this beforehand, and you suggested making an adjustment to the claim that would have probably completely eliminated the problem from the start, right?
Novartis wanted a broader interpretation of the term. So this generic company would be infringing their patent. Novartis argued that in combination, it didn't matter whether it was complex or if it wasn't a complex. But the MSN, who was the putative infringer, argued that Novartis's claim did not include this complex because this complex was not discovered until later. And so the generic company, which actually wanted to put this complex out there, wanted the claim not to read on the complex, so they would be free of infringement.
But if Novartis had thought to perhaps the dependent claim that claimed the product of the two initial ingredients, then potentially they could have avoided the controversy in the first place. It's probably a little bit challenging if they didn't completely understand the technical basis, but if they had some evidence that a complex was formed, even without knowing about it completely, that could have strengthened their position.
Yeah, without getting into the weeds too much, there is a patent doctrine called claim differentiation. What claim differentiation says is if you file a dependent claim off of a independent claim, the dependent claim has to necessarily be broader than the independent claim. For example, if they had filed a dependent claim to the complex, that would have made the broader claim include not just the complex, but it would have made it broader than the complex itself.
Thank you very much, Ben. A very interesting discussion on an important topic that was recently decided by the Federal Circuit. The moral of the story is make sure you're drafting your claims carefully, and that when you're entering the life science patent arena, make sure you have experienced patent attorneys by your side to catch all of these important details that will make your patent as enforceable as possible. This is Richard Gearhart from Gearhart Law signing off. You can reach us at gearhartlaw.com. Contact us with any questions about your life science patent. We'll be happy to help out.